Welcome to Empowered. I'm Elizabeth Naumovski. Having a will is extremely important, and it seems to be a minor thought for many. Wills are a way for the deceased to tell everyone what their wishes are after they die. On previous episodes of Empowered, we've discussed the topic of what to do and look out for when you're named an executor of an estate. Today, we're going to talk about hot topics in estate planning, what to look out for, and what's important and why it's important. I'm joined by Rachel Goldman Robinson, a partner at Torkin Manes LLP. Rachel will walk us through the estate planning process, what's involved to create a good will. Rachel, welcome to Empowered.
Thank you, Liz. It's so nice to see you.
It's great to see you as well. Let's begin, though. When should someone think about having a will prepared?
So when we talk about wills, there's a lot of issues that come up. And I guess the first thing is, what is a will, right? A will is a legal document that allows somebody to dispose of their assets after they pass away. And it can be written by hand, which is called a holograph will, but we focus on wills that are typed up, that are relatively complicated in terms of provisions. But it doesn't have to be. I think the main thing to think about is certainly if a person has children, it's a really important time to think about having a will in place, because a will allows you to make a provision for appointment of guardianship or someone who has decision-making responsibility for your children. And without that, it can cause a lot of issues with people. If both parents are gone, people making applications to the court and fighting. So certainly when people have children, but even if they don't have children and they have assets that are of value, either sentimental value or actual financial value, then it's a document that allows them to dispose of those assets after they pass away in an orderly fashion and appoint the proper people to make the decisions and to help administer the estate. And, if you don't have a will, there's a lot of issues that come into play. So certainly as soon as somebody has an asset or as soon as somebody has children, it's a really good time to think about what's going to happen to the children and to the assets after they pass away.
So I want to dig into probate. A lot of people are terrified of it. It's like, oh, I don't want to go through probate. So could you please explain what is probate?
So we get asked that question all the time. So probate it's actually a slang term for a certificate of appointment of a state trustee, which is issued by the court. And it's a process where the executors submit the will to court for the court to certify that this is the valid document of the deceased. So if you think of it in a simple term, let's say somebody has a bank account at a bank and there's $50,000 in the bank, and they pass away, and I show up at the bank and I have a will from the deceased and I have a death certificate, and I say to the bank, can I please have access to the account? Well, if the bank gives me access today to that account and tomorrow you show up with a later dated will and a death certificate, and you say, no, actually, I'm the executor, this will is the valid will, but the bank had already given me the access to the account, then the bank is liable because they improperly gave the funds to somebody else. So large financial institutions, for example, won't give access to those accounts without something that they can rely on, so that if you came the next day, they can say, well, I relied on this document from the court that told me that this is the valid will. So the banks will ask for what we call a probated will. And that's a will that was submitted to the court, and it was certified by the court because the executors who submitted the will swore affidavits, they gave notice to the beneficiaries. And so it's a process that the will basically gets vetted and a document gets issued that these third-party institutions can rely upon and then release the funds. Now, the issue with probate is that in making that application, you have to pay, in Ontario, approximately 1.5% probate fees on the value of the assets that are under probate. So if a deceased had one will, even if certain assets don't need this probatable document, you have to include the value of the entire estate in that probate application, and the entire estate is subject to the 1.5% probate fee. We do lots of probate planning strategies, and one of those is having dual wills, where we carve out certain assets so that we don't have to pay that 1.5% probate fee. But if there's only one will, then all assets of the estate would be subject to that. Now, it's really important to know that...
Just hold that thought for a moment. Hold that important thought, because unfortunately, I really have to go to commercial break. So please don't go away. We'll be right back with more. Welcome back to Empowered. I'm Elizabeth Naumovski. Today we're discussing hot topics in estate planning. So please, Rachel, continue.
So what's really important to know about probate is that it's not a mandatory requirement. It isn't required in every case. And the will actually gives the legal authority to the person named as the executor to deal with the assets. So for example, we as lawyers, we can transfer shares in a private corporation without the need for a probated will. If we feel comfortable with the estate and with the client and we know the background, the will itself will gives the executor the legal authority to give us the directions that we can act upon to transfer the shares. It's just the certain assets, the nature of certain assets and institutions where those assets are held that determine whether or not there's a probate requirement. That being said, we do need a will in order to transfer those corporate shares. So in the case where somebody dies, let's say without a will, even though there are corporate shares, we still can't transfer them as the lawyers because we need somebody to have the legal authority. And in that case, that somebody would have to apply to the court in order to be certified.
So let's talk about probate tax and how it's different from income tax that's due upon death, because that confuses a lot of people.
Yeah, for sure. A lot of people ask this question. And I look at probate fees as more of an administrative fee that's imposed on the estate. Like I said before, it's approximately 1.5% of the value of the assets that require probate, or the value of the total estate if there's only one will, or if you end up making an application to the court because there is no will. That's more of an administrative fee, and we do a lot of planning around minimizing the probate fees that are payable. Income tax is different. So when a person dies in Canada, they're deemed to have sold all of their assets. And capital gains tax is payable and owing on capital assets that have appreciated in value from the time that they were acquired. There are certain exceptions for that. There are exceptions if the assets pass to a surviving spouse, either outright or through a qualifying spousal trust. There's another exception to the capital gains tax, which is the principal residence exemption for real estate. But otherwise, so let's say assets that pass to children on death, those would be subject to capital gains tax. So we always say to our clients, you want to look at what kind of disposition you're going to do, and you also want to look at your assets and to make sure that there's sufficient liquidity in the estate. If there is going to be tax owing, how is that tax going to be funded? So we look at life insurance, joint last to die life insurance policies, or sources of liquidity to make sure that that tax is funded, because it ends up being a charge on the estate. You have to have the money in the estate to fund the taxes before you can actually dispose of the assets entirely to the beneficiaries.
I want to state how important it is to use an estate planning lawyer to put together your will. I've heard of families using a real estate lawyer because it was a friend, or it was easy. So let's just quickly talk about the fact that you really shouldn't use a real estate lawyer for your estate. And then what happens if someone dies without a will?
Yeah, it's a really good point. And we see this all the time. We see wills that were done by practitioners who don't focus in estates law. The thing with estates law is that it is changing all the time. The government is coming out with changes, changes to drafting, changes to our structures. And you certainly don't want somebody who doesn't specialize in this to be dabbling in it. Just like I wouldn't do a real estate transaction. We do lots of real estate transfers. We do lots of corporate transactions. I don't touch that stuff. I work with the real estate lawyers and the corporate lawyers and the family law lawyers. So with wills, I absolutely recommend that you have a specialist look at the documents, because we are constantly dealing with documents that were poorly drafted. And the problem in the wills and estates world is that when those documents come into play, the clients who originally did the documents are dead. So they can't rectify them. And it's very hard to deal with problems that were done that could have been avoided if you had a specialist. You asked what happens if somebody dies without a will. Well, I mean, I could talk for an hour on the intestacy process, which we won't. Yeah. But I can tell you high level what happens and what we do in that scenario. It's called dying intestate. And if somebody dies without a will, you have to make an application to the court, like I said before, for somebody or a group of people to be certified to be the estate trustees without a will. and the assets are basically frozen. Nobody can do anything with the assets. We, the lawyers, the banks, we don't have anybody who has legal authority to deal with that. I've had a case that was super frustrating for the wife.
Rachel, one moment, please. Hold on to that case that was frustrating for the wife, because again, we've got to go to commercial break. So please don't go away. We'll be right back. Welcome back to Empowered. I'm Elizabeth Naumovski. Today we're discussing hot topics in estate planning. And Rachel, before we went to break, you were going to give us an example.
Right. So I had a wife who came to me a number of years ago, and she said, well, my husband died and he didn't have a will, but all he owned was shares of our private company. He was the sole shareholder and the shares are worth about $10 million. So what can we do? Had he had even a simple one-page will that appointed somebody to administer, be the executor of the estate, we as the lawyers could have dealt with that. We wouldn't have had to involve the courts. But because he died without a will, we had to make an application to the court, and they had to pay about $500,000 in probate fees to the court. And then not only did we have to deal with that issue, but then you had to deal with that everything didn't automatically go to her under the laws of intestacy. And we had to deal with capital gains tax that was going to be owing because assets from those shares were going to go to the children. So it became this huge headache that really could have been avoided very easily with a simple will, even just one will. And in addition to those issues, there's also the costly side of not having a will and having to make the court application and to go through the steps of applying and distribution.
So we talked about not having a will, but what does it mean to have dual wills?
So dual wills is something that we've been doing in Ontario for a long time, since the Naumovski case back in the late 90s. And dual wills allows people to segregate assets, essentially, so that you have one will that gets submitted to the court for probate. So let's say you have that bank account at the bank and the bank is requiring a probated will, then the value of that asset would go into the probate application. But let's say you also had those $10 million corporate shares. Those shares would be dealt with under the secondary will and not be subject to probate fees. So you end up sheltering any assets that don't require this probate document from the probate fee. And it's planning that we do all the time. And in addition to that, we work hard to actually move assets that otherwise would be probatable into a form that would have them qualify under that secondary non-probatable will, so that we avoid the probate fees on those assets.
So then let's just take it the next level. We have so many snowbirds in Canada, whether they're going to Mexico, they're going to Florida, they're going to Arizona. I mean, they all have properties. What happens when you create your will and you live in Ontario, you live in Alberta, it doesn't matter where you live in Canada, but you've got a foreign property in there, let's say even a US property?
So we always tell our clients, when you have foreign properties, you should have a will prepared in that jurisdiction to deal with the property. The transfer laws and the rules in those foreign jurisdictions are different from ours. For administratively, it's much easier to have a will dealt with there, and for tax purposes as well. So we normally connect our clients with lawyers in the other jurisdictions. We work closely with them, and we make sure that our wills and those foreign wills work together to ensure that neither will revokes the other and that they coordinate properly. But we certainly say get the proper advice there, and not only having a will in the foreign jurisdiction, but also having a power of attorney for property. Because if something happens to the person while they're in Italy or the US or whatnot, and they need somebody to deal with the property, they want to have a document that's recognized there, because our powers of attorney aren't necessarily recognized there. So they want to have a document that's recognized there that will appoint somebody to be able to manage that asset.
So what advice do you give to parents who want to make gifts to one child during their lifetime, but not to the other children?
Well, that is a question that is asked often. We always say that if you do want to do that, you should document your intention so that it's clear what you're doing and how this giving of money is being structured. So is it a deed of gift? Are you putting a mortgage on a property? Is it a promissory note that has to be repaid? To avoid resentment of the other children, sometimes they might consider having a family meeting to the extent possible, or letting the other children know about these advances or gifts. It's not always practical, but I do have a number of families that have this structure where all the children know. If they're loans, they have comprehensive spreadsheets and they have either repayment plans, or they have talked about how there will be an equalization at the end of the day from the shares that the other children will get from the estate. I also caution clients about gifting money during their lifetime to their children and depleting their own assets, because you want to make sure that there's enough money in their estate for their needs down the road. And end of life care is really expensive. So, we always talk about that whenever they do talk about gifting. But like I said, the question is really whether they want to bring it into equalization in the distribution.
Okay, so equalization and distribution, hang on, don't go away. Welcome back to Empowered. I'm Elizabeth Naumovski. I'm joined by Rachel Goldman Robinson, a partner at Torkin Manes LLP. And Rachel's been walking us through the estate planning process and what's involved. Before we went to commercial break, you were talking about equalization and distribution.
If parents are gifting money or loaning money to a child or children during their lifetime, what happens to it if it was a loan or if it was a gift? What happens on death of the parent? So do the parents want to have it considered on death and equalized against the other children? Or is it just a gift that was made during the parent's lifetime and not to be considered? The will can reference the amounts given during the testator's lifetime. If the amount given was intended to be a loan, and let's say it had a documented promissory note, for example, then the will can provide language to take into account whatever may still be owing by the child at that testator's death when dividing the estate, and can reduce the child's share accordingly and forgive the debt. If the testator wants to take into account gifts that were made during the lifetime, it's also important that the testator documents those gifts to avoid children fighting over what gifts actually qualify for the equalization. So in any case, I say to our clients, make sure that you document it and you give it to us, that document, and keep it together with the will. And I have a number of clients who annually provide us with updated spreadsheets or loan documents so that there's really no confusion at the end of the day what the intention is and what the dollar values are.
So I want to talk about real estate as well, because there's so many families that have cottages. What do you advise clients when it comes to, the hot topic of the family cottage?
And that is a hot topic. And it is one of the most litigated areas of estates law, family cottages and succession planning. And there's tons to consider. And we talk about it probably every week with clients. And it's tough because a lot of the clients feel an emotional attachment to the cottage, and they ideally want their children to continue that and work together. But the reality is it gets very complicated. We can set up trusts. I caution against setting up long-term trusts where you're forcing the children to interact. This is now the next generation. There are spouses that have to be considered, grandchildren. You have to look at the children's financial situations, the children's residency. So you run into issues where you want to set up a trust for the cottage, but one child lives in around the world and is never going to use the cottage. And now his share of the estate is going to be depleted by carrying costs for a cottage that he's not going to use. So we talk through the practicalities. I actually am seeing more and more people saying that actually hold the cottage for a year or two and then let the kids decide what they want to do with it or sell it if they can't, because I think that they're understanding that it can be really tough for the next generation to work together to maintain this property.
So we talked about children. Is it a good idea to put your children down as executors? Because as you mentioned, some live around the world, some don't even talk to each other, some are estranged from the family, yet parents always want to put the children together.
Yeah. So we get this question too. If the parents think that the children are going to fight, we say don't put them together, because if they're going to end up fighting and they have to work together, the estate won't be able to be administered. So if the children get along, then it works beautifully. And we see that in a lot of the cases. I have clients who have children who don't necessarily get along and they want to appoint just one child to manage the estate and be the executor, which works. But they have to understand that they're putting a heavy burden on that child because that child is now going to be administering the estate on behalf of all beneficiaries and steps into a fiduciary role where they have to consider all the interests of the beneficiary. So it can become conflicting. But in an ideal world, they'd be able to talk to the children while they're alive. And we also have, we urge clients to do letter of wishes, side letters that go with the wills where they can talk about, now not only for executors, but for trustees and trusts that we set up in wills, which we do often, and talk about what their personal wishes are with respect to the administration.
So, Rachel, I have 5 seconds left. Should you give the executor the will in advance?
My opinion is no. And that is because this is a continuously changing document, potentially. The executors come and go in terms of appointments during the person's lifetime. The will is only effective and legally binding once the person passes away. So I say no, give us the will, we keep it in the vault. And when the time comes for it to actually be acted upon, we gladly give it to the named executors.
Great. Thank you so much, Rachel.
Thank you.
Rachel would like you to know that estate planning can be a complicated and highly emotional process. Remember, a will is your voice for your wishes once you're gone. I'm Elizabeth Naumovski, and I'm here to empower you and make frugality fashionable. Bye for now.